Hey everybody, this is Attorney Kenneth Stevens, and today what I'd like to talk to you all about is the language "time is of the essence." Now this is something that should be in all of your contracts, but lately I've looked at some different contracts. I've been involved in litigation involving contracts where delays are alleged, and I don't see this language. Now, this language is important both for the contractor and for the owner, because this language can dictate when actions have to be taken. It's not just related to when the project has to be completed. Yes, you do often see it in that context, and it should be in your contract in that context. The contract should have a substantial completion date and then say time is of the essence. If it doesn't, that means that time is not of the essence, and if the contractor is late in their performance and the circumstances surrounding them being late are reasonable, then that's not going to be a material breach of the contract. You know, there's plenty of case law out there that says that normally time is not of the essence, and unless that language is specifically in the contractor is not going to be held to have materially breached the contract just because they're a little late on finishing the project. So owners, developers, if you want this project completed on time by a very specific date, then you need to put that language in your agreement. Now, contractors, you want this language in the agreement as it relates to your payments, because guess what? If you don't put that time is of the essence and the owner or the developer is a few days late, a week late making your payments, that could be considered reasonable. And then, you got all kind of cash flow issues that come for that. Last thing I want to share with you both, and what's really, really important, is that if you put that language in your contract, then you need to hold the party to the language of the contract. What do I mean by that? It has been said, there's case law out there that a party can waive their right to enforce the time is of the essence clause. Basically, if, for example, contractor, you allow an owner to pay you 2 weeks, 3 weeks late on the first draw, and then 2 weeks, 3 weeks late on the second draw, and the third draw, and the fourth draw, and so on and so forth, and then let's say 6 or 7 invoices in, you then say to the owner, hey, I'm not going to accept this late payment. You've materially breached the contract. The courts have said, no. You've allowed this to go on so long that time is no longer of the essence. They no longer have to pay you on the specific dates that you requested. If they're a few days later, if they're 2 or 3 weeks late because you've allowed it, they're reasonable in thinking now that they can pay you 2 or 3 weeks late. So it's very important that if you're going to put this language in your agreement, that you do hold them accountable for the material breach. Anyway, I hope this is helpful. You all share it, and happy building.